I want to tell you about him before I tell you about the case, because by the time most people hear about cases like this one, the person at the center of it has already become a number in a file. He was not a number to me. He never was. He was a 31-year-old man who drove an ambulance on Tuesday nights and Sunday mornings and whatever shift they called him for, because that is what people like Marcus do. They show up. I have held this story for a long time, not because I was afraid to tell it, because I wanted to tell it right. Subscribe and turn on notifications. That is the only reason I am here today, to tell it right to the right people. Subscribe before I keep going. The silence I remember most came last. I'm going to tell you about two others before I get there, but the one that has stayed with me is the one that fell over that courtroom the moment I finished speaking the sentence. Not the sentence I prepared the night before. The one that arrived only when I was already speaking it, when I understood that the law allowed me to say it and that saying it was the only right thing left to do. The room went still in a way I had not heard it go still in 22 years on the bench. I want to tell you how we arrived at that silence. That means I have to start earlier. It means I have to start with Marcus. And it means I have to start with Dominic Vielle. I met Marcus Riley for the first time on a Monday in February. He walked into my courtroom with his left arm in a brace and a slight tilt to his posture that I recognized before I understood it. He was compensating. He had been compensating for months by that point, 6 months since the incident, and his body had started to treat the adjustment as normal. He sat in the gallery before he was called, and he put his hands flat on his thighs and looked at the front of the room without looking at anything in particular. I have seen that kind of looking before. It is the looking of someone waiting to be told what their suffering is worth in official terms. The one thing Marcus did during the proceedings that I have not forgotten was small. During the third day of testimony, while a paramedic supervisor was describing the layout of the ambulance bay, Marcus took a folded piece of paper from his jacket pocket and smoothed it flat on his knee. He did not look at it. He just smoothed it. Then he folded it back and put it away. I do not know what was on that paper. I never asked. But the gesture told me something about what it costs a person to sit still while other people describe the moment that changed their life. Dominic Vielle was 44 years old and famous in the way a certain tier of person is famous, recognized in restaurants, photographed at events, wealthy enough that the people around him had stopped telling him when he was wrong. He arrived in my courtroom in a charcoal suit that cost more than most people in that room made in a month. I am not saying that to indict him. I am saying it because it was visible, and visibility matters in a courtroom where someone with a brace on their arm is trying to tell you he cannot do the only job he ever wanted to do. Vielle sat at the defense table with the particular stillness of someone who had been told by counsel to appear calm and had taken that instruction seriously. His eyes went, when he thought no one was marking it, to his phone. Counsel had placed it face down on the table. He turned it once, checked it, and turned it back. It was before we came to order, but I was already on the bench. I see what happens before things come to order. The one thing I found genuinely human about Dominic Vielle came during a recess on the second day. I was returning from chambers, and I could see through the narrow window in the courtroom door before I entered. Vielle was standing alone, looking at the state seal mounted above the bench. He was not performing anything for anyone. He looked in that moment like a man who understood where he was and was afraid of it. That fear did not excuse what he had done. In some ways it made it worse, because fear means knowing, and knowing means that what happened was not ignorance, it was choice. If something in what I have said so far has stayed in your chest, subscribe, because what I am about to tell you next will stay longer. Subscribe now, and then let me keep going. On the evening of August 14th at 7:22 p.m., Dominic Vielle parked his Rolls Royce Cullinan in the ambulance bay of St. Benedictine Medical Center on Halcourt Avenue. He parked it there because the valet line at the adjacent event pavilion was, in his words during testimony, backed up past the point of reasonable. He left the vehicle there and walked into a charity gala that had his name on the guest list, 41 minutes past. At 7:58 p.m., an ambulance carrying a man named Kevin Farrow, who had suffered a crush injury to his right hand and forearm, arrived at St. Benedictine and found the bay blocked. The driver was Marcus Riley. He radioed ahead. The bay remained blocked. Marcus made the decision, as he was trained to maneuver around the obstruction. In the specific geometry of that bay, the ambulance clipped the rear quarter panel of the Cullinan. The jolt was minor by collision standards. It was not minor to Marcus, who, in bracing against the impact, twisted his shoulder against the door frame at an angle that tore the rotator cuff he had surgically repaired 2 years before. Kevin Farrow received care that night, delayed by 11 minutes. His hand was saved. I want you to know that because it is true and it matters. Marcus Riley was placed on medical leave the following morning. He has not returned to active duty since. When he testified about the night in question, there was one thing Marcus said that I have said back to myself more than once since the case closed. He said, "I just needed the bay to be clear. That's all I needed." He said it without emphasis, the way a person states a fact about water or weather. He said it and then he looked down at his hands, and the courtroom went entirely still. That was silence one. It lasted about 12 seconds, which is a very long time in a courtroom. I did not break it immediately. The silence was doing something that words would have interrupted. In those 12 seconds, I watched 3 members of the jury close their notebooks. I watched one of them press her lips together in a way that had nothing to do with legal reasoning. I watched defense counsel place both hands flat on the table in front of him. I understood after silence one something I had not fully understood before it, even having read every piece of the file. I understood that Marcus Riley was not asking for anything extraordinary. He was asking for something so basic that the asking of it was itself the evidence. The facts of the case as they came across my desk in the weeks before trial were both simple and not simple in the way that most cases are. The civil filing named Vielle in negligence. The key legal question turned on what is called the duty of care standard as applied to a private citizen blocking emergency access infrastructure. In plain terms, the law asks not just whether you did something harmful, but whether a reasonable person in your position would have recognized that harm as a foreseeable consequence of their action. I want to tell you plainly that I found that question almost unbearably easy to answer. There was one moment in the pre-trial process that made me pause, not because it was legally complicated. In the initial response filing, Vielle's legal team argued the Cullinan had been parked for a commercially reasonable duration and cited a statute that applies to loading zones. The statute was real. It simply did not apply to ambulance bays in any jurisdiction I have sat in or studied. Someone had found a statute and tried to make it fit the shape of the situation. I paused on that page, because what it told me was that somewhere in the early hours after this incident, before Marcus had even finished his initial injury report, someone was already building the argument. That is not illegal. That is procedure. But there is a kind of grief in watching procedure move faster than reality. I will tell you what I owe to this bench and nothing more. I am able to manage my own responses. Managing a response is not the same as not having one. Subscribe. I owe it to him to keep telling this story. You subscribing is how his story reaches past this video. Subscribe and stay. The second wave evidence came in the form of security footage and cell tower records. The footage showed the Cullinan entering the ambulance bay at 7:19 p.m. and remaining there until 8:41 p.m., 1 hour and 22 minutes. The cell records placed his phone in active use inside the pavilion throughout. There was nothing about this evidence that required interpretation. It was simply time, documented. A statement from the paramedic supervisor on duty, Teresa Okafor, who had 14 years of experience in emergency bay management, said this, and I wrote it down in my own handwriting on the yellow legal pad I keep to the left of my bench materials. In my 14 years, I have never seen someone treat that bay like a parking structure, never once. I looked at that sentence for a long time before I moved on to the next page. Vielle's testimony came on the third day. His counsel walked him carefully through the evening. Vielle described the valet line and his decision to park in what he called the open space adjacent to the building entrance. The signage in that bay, as established through photographic evidence, included two signs reading Ambulance Bay, no parking, each measuring 24 by 36 inches, each lit by overhead fixtures that were operational throughout the evening. Counsel had already asked about the signs. Vale said he did not register them. Then his counsel asked whether he had any statement regarding the injury to the plaintiff. Vale said, "I feel genuinely terrible about what happened to that gentleman." That gentleman, he had been in the same room as Marcus Riley for 3 days. Marcus's name had been spoken aloud in that courtroom more than 200 times. He said, "That gentleman." I wrote that down too. I set my pen on the pad and I looked at what I had written and I waited. What came next was silence too. It was a different silence than the first. Silence. One was the silence of something true being said so plainly the room had no response ready. Silence. Two was the silence of something said badly, not cruelly, just badly, in a way everyone in the room understood at once. The quality of it was embarrassment without sympathy. One juror looked at the ceiling. The court reporter paused and then resumed. Vile's own counsel shuffled papers with a precision that told me he already knew. The silence lasted 8 seconds. When it ended with my voice. "I am not going to make a case for it. You are already in this story. Subscribe and let me finish it." The defense argued that Vale's culpability was limited by the hospital's response time in clearing the bay. They were not wrong that those factors existed. What they could not argue, and what I found ultimately decisive, was the sequence. The bay was blocked. The ambulance arrived. A person was injured. The sequence does not require interpretation. It requires an honest account of what caused what. The one moment the defense came close was when an expert witness testified that rotator cuff re-injuries could occur beyond the triggering incident, that the prior surgery itself created vulnerability. I paused on that. I thought about it overnight. I came back the next morning and thought about it again. And what I came back to was this. The question was not whether Marcus's shoulder was vulnerable. The question was what made that vulnerability the law's concern that evening. The answer had not changed. The thing I want to place next to this case is a memory. A Tuesday afternoon in September, about 15 years ago. My daughter was 8. She had a recital. A school gymnasium, folding chairs, nothing more. I was on my way when a call came about a scheduling matter that was not truly urgent, and I handled it in my car in the parking lot while the recital started without me. I walked in 12 minutes late. She was already at the microphone. She saw me come in and she smiled and looked back at her music. After, on the drive home, she told me her favorite part had been the opening. She said it without complaint. Just as information. I have thought about that for 15 years, about how a person can miss the opening to something and receive no accusation and still know exactly what they missed. I do not draw the connection for you. You already feel it. Vile submitted a written statement prior to sentencing expressing remorse and noting his charitable work. He was not wrong about the charitable work. It is documented and real. It is also not relevant to what I was being asked to decide. I want to tell you about the silence after my sentence landed. I had been building toward it for weeks. Every note on the yellow pad, every overnight thought had been pointing toward what I said that morning. When I finished speaking, the room did not make a sound for what I believe was 18 seconds, long enough that I was aware of my own breathing, long enough that I could hear from the back of the gallery the very faint sound of someone covering their mouth with their hand. Marcus Riley did not move. He sat the way he had sat every morning, hands flat on his thighs, but something in his posture had shifted slightly, and I did not name it because naming it felt like an intrusion. Vile sat very still. His counsel placed one hand briefly on the table. That was silence 3, the one I have been carrying since. This is what I ordered. I'm speaking it again here to you the way I spoke it then. I ordered Dominic Vale to pay $840,000 in compensatory damages to Marcus Riley directly, covering medical expenses, lost income projected across the duration of his incapacitation, and future reduced earning capacity based on the modified duty determination. I arrived at that number carefully with a medical economist, with Marcus's employment records, and with my own understanding that a number that is technically sufficient and a number that is honest about what was taken are not always the same number. I intended to arrive at the second one. I ordered a separate payment of $250,000 to the St. Benedictine Emergency Services Training and Infrastructure Fund, designated specifically for bay access protocols and staff safety improvements. The harm done was not only to Marcus, it was to the function of that bay, to every patient who arrives and needs it clear. The money needed to go to the place that could make the bay better. I suspended Dominic Vail's driver's license in this state for 18 months, effective immediately. What that means for a man in his position is that every trip requires arrangement, every meeting, every evening. For 18 months he will need to ask someone else to take him where he wants to go. I did not order this to embarrass him. I ordered it because the driving of a vehicle requires a standard of attention to consequence that the evidence did not show he was currently meeting. I ordered 120 hours of community service assigned specifically to the emergency transport unit of the city's public health service, not general volunteering, specific placement. He would be in the environment his choices had damaged. He would know by name and by face the people who do the work he blocked. I ordered Vail to appear in person at the annual staff recognition ceremony of St. Benedictine Medical Center and to deliver a written public statement, a minimum of 500 words, read aloud by him, in the presence of emergency services staff, acknowledging specifically what occurred on August 14th and its consequences, not a general apology, a specific account. And I ordered that Dominic Vail fund, within 60 days, a full course of physical therapy for Marcus Riley, with a provider of Marcus's choosing, including all associated equipment at no cost to Marcus. Not because it was the largest number, because it was the most specific thing I could give back to the specific person who had lost it. Thank you for staying with this. I mean it in the specific way you mean something when it costs you something to say. Subscribe if you have not yet. You already know why you are still here. I want to speak now about what I said to Vail directly in that courtroom, because I have thought about whether to repeat it here, and I have decided the answer is yes. I said, "You made a choice on the evening of August 14th that ensured a man who had spent his career running toward emergencies could not do his job. You made that choice because your convenience felt like a reasonable reason, because nothing in your life up to that point had required you to feel the difference between an inconvenience and a harm. Marcus Riley felt that difference for you. He felt it in his shoulder and in his livelihood and in the space between what he could do before that evening and what he can do now. That gap is not an abstract number on a court document. It is a person. To Vail's family who were present, I said only this: I know you love him. What happened here is not the whole of who he is. It is the part the law was asked to address, and I have addressed it. To Vail himself, I said, you had, at the time of this incident, more resources and more choices than almost anyone who will ever stand in this courtroom. What your position required of you was the small act of looking at a sign and taking it seriously. That is all. That is the whole of it. And the last thing I said in that courtroom was not about Dominic Vail. It was about Marcus Riley. It was this: he showed up for strangers on Tuesday nights and Sunday mornings, and whatever shift they called him for, he is still showing up in whatever capacity they will allow him. That is who this case was about. I want the record to reflect that. Vail's legal team filed an appeal with the appellate division on April 3rd. The appellate court upheld the ruling on July 19th. 4 months and 14 days after filing. The ruling stated in plain language that the lower court's application of the duty of care standard was consistent with established precedent and that no reversible error had been identified. I was not surprised by the appeal. Reading the affirmation was not relief. It was the feeling of arriving at a place you were already sure of and finding it unchanged. After I spoke the sentence, the courtroom began to empty slowly. I remained on the bench. Marcus's wife, who had been in the gallery every day of the trial, stood and went to him and did not say anything. She simply stood beside him with her hand on his shoulder, the one that still worked the way it was supposed to. He reached up and covered her hand with his. They walked out together. Teresa Okafor stopped at the gallery railing on her way out and said to a colleague quietly, "Good." One word. Then the room was nearly empty and I finally stood. The afternoon light came through the side windows and sat on the backs of the chairs in the gallery. The chairs were just chairs. The light was just light. I stayed with it for a moment before I gathered my notes. 1 month after the verdict, on March 7th, I received word through Marcus's attorney that he had been cleared for modified return to duty with the ambulance service, not full active, modified. He would be dispatching, coordinating, not driving. The attorney sent a brief note. I read it twice and set it in the corner of my desk where I keep things I want to remember are real. I keep returning to a question I have not been able to answer in all the time since this case closed. It is not a legal question. It is this. What does a person owe to the simple idea that other people are real? Not legally owe, just owe, in the ordinary way. I do not know. I have been thinking about it since August of the year in question, and I am still thinking. What this case reminded me is that grief and clarity are not opposites. In my experience, one tends to produce the other if you sit with it long enough. I have sat with this case long enough to know that both are present in me every time I think about that bay on Halcourt Avenue at 7:22 in the evening. To anyone who has sat the way Marcus sat in that room, waiting to hear what your suffering is worth in official terms, with your hands flat on your thighs and a folded piece of paper in your pocket, I recognized what I saw in your face. I have seen it before. It is the face of someone who has been asked to shrink their pain to fit the available space for it, who has done everything asked of them with a patience that was not weakness, but will. I could not say that from the bench in the way it needed to be said. I am saying it now. To anyone who has done what Vial did in any version of it, I want to ask you the question I could not ask from the bench. Did you see the sign? Not the literal sign, though I mean that too. Did you see the sign that said other people were coming through that space and needed it clear? If you saw it and looked away, here is the one thing I will offer. There is still time to be someone who looks at signs. There is still time to ask, before you park, who needs this space. That is not a small thing. That is the whole thing. Marcus, that is why I told you this story. If you want to hear the others, and there are others, subscribe. That is all I am asking. Subscribe and stay. If something in what I have said today has stayed with you, leave it in the comments, not for debate, just to say you were here, that you listened. Some stories need more people to carry them than were in the room when they happened.